welcome to another ActiveProspect webinar. This is one of the many content pieces that we've been putting together and will continue in the weeks and months ahead as we help the lead generation and performance marketing industry navigate the most recent FCC one-to-one consent rules and the related updates to the TCPA, our Telephone Consumer Protection Act. We believe the content we're putting together will help you decode these changes with more confidence and a focus on compliance. Today's topic: alignment, auditing, and adherence, the AAA approach to TCPA compliance. Also, it's time to turn TCPA compliance into an advantage. So some housekeeping information on our platform before we get started. There is a chat icon and a questions icon. We encourage you to ask questions, and we have someone monitoring them throughout the presentation today. Please use the chat section for general comments and interactions with other participants. And please use the question section if there's items you'd like to pose to us. We're going to leave time at the end to review and respond to questions, but we'll also keep an eye out on questions during the session. We'll have a brief 2-minute survey that will pop up on the screen at the end. Please let us know how we did, and please let us know what you'd like to hear in the future. And the live recording will be emailed out tomorrow morning for you to share with your colleagues. Hello, I'm Benjamin Farrar. I'm the Director of Privacy, Security, Compliance at ActiveProspect. For the past 20 years, I've worked for companies in the performance marketing and market research space, including Dentsu and WPP Kantar, with much focus on privacy and data regulation compliance. I also worked at Ernst & Young in New York as an IT controls auditor and financial services, and in the internal firm's privacy compliance program. Prior to that, I worked as an auditor at Oshner Clinic Hospital in New Orleans, Louisiana, so covering the healthcare and insurance industry. All of my roles and functions or departments focused on legal, compliance, privacy, IT audit, and data security. And one clear development has followed me through my career. In every one of those industries and jobs, a significant data regulation or law was passed, and I was on the team responsible with others for reviewing and translating these new rules, working to see clarity and establishing a compliance program around them. And now for a brief background and introduction, I would like to pass the mic to one of my co-hosts today, Michael Peronto, Director of Professional Services at ActiveProspect. Michael.
Awesome. Thank you so much, Ben. Happy to see everybody here. So again, my name is Michael Peronto. I'm the Director of Professional Services here at ActiveProspect. Just a little bit of background about myself. I've been in the CRM, contact center, and lead marketing space for over 13 years. I've previously worked for CRM companies, including Velocify and Shape Software. I've done implementations of contact center softwares, including Five9, NICE, and Contact, as well as provided consultation services to firms that use those services. One of my previous work experiences, I was the director of lead marketing for Cardinal Financial Company Limited Partnership, where I oversaw a multi-million-dollar monthly lead buy. I was also the day-to-day administrator of the various platforms that they used. The reason why I provided you that little bit of context is because when I speak throughout this webinar, I will often speak from my experience, being a customer and using those types of services and making recommendations on best practices for using those softwares. With that in mind, I'd like to pass it over to Peggy Daley. Peggy, you're on mute.
There, fixed.
There we go.
Sorry about that.
Okay.
Thanks very much for having me here. My name is Peggy Daley. I'm a vice president at Charles River Associates in our forensic services practice. For the first part of my career, I was a trial lawyer and also did a lot of internal investigations and worked a lot in structured data. Since 2015, I've worked as an expert witness in mostly consumer class actions. So I've probably been an expert witness in more than 50 TCPA cases. And what our work entails is typically analyzing the underlying business records, the call records, the consent records, the consumer records, and assisting the clients in determining whether or not a class can be identified out of that data. If so, what type of class, whether they not only can be ascertained, but is there consent defenses that could defeat the cases. So that's why I'm here. That's my background.
Excellent. And also joining us today is Benjamin Zitter, Chief Compliance Officer from What If Media Group. Benjamin.
Yes, hello everyone, and thanks for having me today. As Ben mentioned, I'm the Chief Compliance Officer of What If Media Group. I've been in that function for about the last 5 or 6 years, but I've been within the What If Media Group family for about the last 12 or 13 years. So a lot of experience in the performance marketing industry, and played a big role in developing the current compliance practice that we have here at What If Media Group. So we have a lot of focus on certainly TCPA compliance. It can span for email and several other areas that we cover in terms of marketing channels. Before that, I was primarily in auditing for transaction advisory firms. Also did some forensic accounting for a few years. So I also have a lot of experience with internal auditing and accounting.
Excellent, excellent. Really happy to have both of you with us today, and it's great to feature a client who uses our services. I know What If Media Group does, so it's really good to have others sort of sit in on our conversation and hear what we're talking about, particularly with the FCC one-to-one consent changes. So, Ben, first question in this area. So I know you've been following the developments very closely, from the developments from last year until the finalization of these changes to the TCPA. Give us an overview first of your company, What If Media Group, what it does, and then next we'll pivot into how you started interpreting these changes as they were being developed over the recent months.
Sure. Yeah, so here at What If Media Group, we are a premier performance marketing company that leverages proprietary media and first-party collected data and our homegrown AI platform, which we call ARIA, to drive targeted customer acquisition for leading advertisers. To do this, we use a broad spectrum of proprietary marketing channels in order to drive performance for our clients, which spans not just the web and TCPA compliant telemarketing, but also email, push, and direct mail. This has allowed us to develop a robust cross-channel offer matching system where we can determine the right offers and opportunities to serve to consumers at the right times and also via the right channels. And something to highlight from this is we really take pride in our ability to leverage our own first-party media to collect consumer opt-in data directly from the source. And consumers who opt into our media will have the opportunity to engage with a variety of exciting optional offerings from both us and our advertisers. But also, given the focus of our call here today, we're very passionate about our compliance practices involved with presenting these opportunities to consumers. Spent a lot of time developing an internal platform that efficiently processes consumer feedback, whether that be DMC requests, data privacy requests. We want to make sure that we're only marketing to engage consumers who are truly interested in what our advertisers have to offer. And needless to say, this is a huge value add for our clients as we generate leads who are truly interested in their products and services. And also to highlight, of course, TCPA consent documentation. It's immensely important for us to document consumer consent along the way. And Trusted Form has been a critical tool for us when it comes to this documentation. So, we're certainly proud of our partnership with ActiveProspect and Trusted Form.
Yeah, thank you. So as I mentioned, as these developments were happening over the recent months with the one-to-one consent changes, as you all were hearing those and interpreting those, tell us about some of the things that you were looking to analyze in your business, considering those changes, what needed to be updates. It sounds like you already had the principles of, starting from the consumer, from their perspective, a compliance focus in mind, capturing proper consent, all those sort of mechanics that are the basic fundamental ingredients. But how did you look at these changes, and what did What If Media Group start to do to make this operational?
Sure, yeah, and we certainly believe that consumers want choices in the marketplace in order to find themselves the best possible deal or opportunity out there. And regardless of how we truly feel about the one-to-one rule, regardless of that, we want to build upon our existing compliance practices to ensure that consumers understand the opportunities being presented to them while they engage with our media. So for us right now, we feel fortunate that we're in a position where we can devote heavy internal resources to testing, strategizing, which enables us to have success with it. And while January 25th, the effective date of the consent of the one-to-one consent order, that'll be here before you know it. There's still time for companies to assess how to best plan for these changes. So, of course, and I guess this is mostly needless to say, but one of the biggest things we continue to focus on is continue to make what we feel are already robust and compliant TCPA disclosures even stronger wherever we can. So it's clearer on a given TCPA opt-in form that a consumer can be contacted based on their engagement and if they consent. And then for where we're at right now in terms of strategy and planning for the changes, since we're not fully there yet, some things we're looking at are ways to auto-populate disclosures on our TCPA forms that highlights just a single seller, the end buyer of our lead. Considering instances for non-regulated dialing technology where we might be able to use that, and also working on opportunities for exclusive advertiser relationships to allow us to have the one-to-one setup. So we're certainly still in process of fine-tuning how we're going to tackle those various options and how we can integrate that into our practice. And also, too, one thing that's been a big topic of discussion lately is, as it concerns TCPA consent and the documentation, is ensuring that our clients who we generate trusted form certificates for example, whether it be trusted form or a similar service, the buyer of those leads absolutely needs to claim and retain copies of those certificates.
Yes.
It's not enough for us to just generate those certificates for them and no one retains them. So we're trying to educate our clients on that end as much as possible. So we're aligned moving forward on that front.
Yeah, Ben, I think you brought up there was a really important component there where you talked a lot about the disclosures and the disclosure language that are presented on your lead forms. You're an avid user of the trusted form product. Basically you're generating that certificate, which has the key data points, including a playback of the lead event that's there. But, one of the focuses that we've really driven in some of our previous webinars, and even in this one as well, is the importance of having disclosures that provide the one-to-one consent, as well as also have important key components in regards to the TCPA, like saying, hey, I provide my express written consent to be contacted by automated dialing, text messaging, even if they're on a federal and state do not call lists, etc. And we always tell our customers that if you are purchasing leads, that you need to be actively reviewing these disclosures with your vendors. And, there's a lot of back and forth that goes along with this. When you get the disclosures from the vendor, you're looking through, you're reviewing them, you can come to a mutual agreement on what those disclosure languages could say. But the disclosures are very, very important. And it's important that you use tools to be able to actively monitor those disclosures and determine if you are going to be accepting leads into your CRM based on that disclosure language. So with that in mind, we do have a quick poll question here for the audience. Where are you in the journey of updating your technology and internal procedures to the FCC's one-to-one consent changes? So as you go through, we do encourage you to answer that poll. And we're just going to go ahead and continue, and we will go and move on with this webinar.
And that section is for all those in the audience. click the poll icon with the bars on the top right to submit your responses, and we'll circle back to that later on.
Great. So as we go through, we're going to review the answers to that poll. Peggy, I have a quick question for you. So we have, obviously these FCC one-to-one rule changes are going to be coming into effect, and you are well aware that there are these known litigants that are out there. How soon do you expect these known litigants to start trying cases in regards to the one-to-one consent rule in court? And then in addition, it'd be interesting to hear your thoughts on some things that our audience members should consider when they're working with third-party vendors that provide like either live transfer services or automated communication tools to their leads.
Peggy, you're on mute.
Sorry about that again. I would expect instantaneous lawsuits because, where the delta on compliance is when it goes into effect and then when everybody else starts getting sued for it. and then everybody starts to think, oh, this is a problem. We should really get on this, right? I saw this verdict. We were thinking about it. We had meetings about it. We did something. But when you start to see your peers get tagged, it escalates your efforts typically. I mean, that's just the way business works, right? And so I think you can, and so there's going to be a lot of, it's going to be like hunting fish in a barrel right after the rules take effect into when, people start to wake up and realize that there's a heavy risk profile and they better fix it. So I don't think there's going to be a soft landing for companies that are already in the bullseye. So if you've already been sued for TCPA, if you've already been in the in the bullseye of some of these plaintiffs' lawyers, you can expect that they will immediately start tracking what you're doing the day it's required. The companies below the radar may have a little bit more, more time, but I don't think you should expect there to be a period of time in which the plaintiff's bar gives you a break.
Right.
I don't think that's going to happen. With regard to third-party vendors, we see them in a couple of contexts. Oftentimes it's I'm buying leads and I'm going to call them on my own, or I'm buying leads from somebody who bought leads, who bought leads. We see it in call centers. I want to outsource my calling and then I'll take the warm transfers, or the whole thing can be outsourced. There's a number of ways, number of channels in which third-party vendors come into play. And what's important to know is that there is no see no evil, hear no evil defense. What happens is they're typically considered your agent. And it really kind of doesn't matter how great your contracts are, but they're often going to be seen, and certainly the plaintiff's lawyers will argue that they're your agents, and therefore you're responsible for any violations as if you did them yourself. That being the case, that means you need to vet them so that you are confident, and not vet them once on the intake, because everybody looks good on the first date, right? So, you start looking a little raggedy a year in, right? So you want to continue to audit, continue to vet over time. And in fact, it's probably more important after the relationship has started, because now they are doing it on your behalf, right? So it's very, very important to make sure that a number of areas are checked off in advance of the relationship, and then others as it goes on. In advance of the relationship, you want to have the right to audit. You want to have a cooperation clause if you all get sued, right? So that all the documents and everything that you need are going to show up. You're going to need to vet them for their own viability, okay? Oftentimes, some of these, we've seen lots of, extremely professional lead gens, and we've seen sketchy lead gens. You want to be with the extremely professional lead gen, extremely professional call centers. When you start working with those that are sketchy, just started yesterday, or it's the serial. This is the 10th company this guy has had. He keeps closing them down, and whatever. You're going to run into issues there, because those are the companies that we see that don't cooperate, that disappear, that maybe outsourced all their lead gen to 400 other companies, bought sketchy stuff, and you're going to be the one that's left holding the bag. So due diligence in advance of the relationship, both on the reputation of the company and the individuals running it, as well as the policies and procedures and compliance, is really important, because whether you do it or not, you're still going to be responsible. So why not, make sure you're getting into business relationships with people that you're going to feel comfortable have the same high standards that you do with regard to compliance. On a going forward basis, you do want to be able to, if you put in your contract, I want to audit, and then you don't audit, the plaintiff's lawyers are going to stick you with that, right? There's did you have an opportunity? Did you have the right to do this? Yeah, I did. Did you do it? No, I got busy, right? And meanwhile, when you had the right to audit, there may have been some flagrant violations. And by the way, sometimes the flagrant violations are just technical problems that can get fixed, right? I mean, we've seen this a lot when software it changes. All of a sudden the press 5, don't call me anymore, doesn't work for 6 months, because of some technical issue. But the law doesn't care about intent here, right? So the audit's important, not just do you trust the people and the policies, it's from a actual perspective, is it working? And sometimes it's not working because of reasons that nobody really, has a black heart about. So what we do in our cases to defend these companies, when I'm on the defense side, is they will ask us to demonstrate that consent existed for the types of calls that have been defined as violating the TCPA, and then thus are part of the class. So we will pull a sample of the telephone calls that were made that fit the definition. And then we'll pull all of the records behind it to try and figure out if there was consent. And we are extremely fortunate in that, our clients get consent, but it's sometimes hard to document or find. This is why you go into business with good partners, because your third-party vendors may have all the consent documentation. I mean, we had a case for, a famous retailer where it was a text case and the person opted in, but they couldn't get the information from their third-party vendor for 2.5 years. There was literally a consent that was, it made the whole case go away, but for 2.5 years, that vendor kind of blew them off and didn't send it. Can you imagine paying 2.5 years lawyers' fees? Plus you got an expert witness and all of that when you could have gotten out of the case on day one. So that's really important, is knowing where your consent data is, having very quick access to it, and making sure that your consent data is accurate. By that, I mean, we do a lot of debt collection calls. I know it's not sort of an issue here, but for example, there's this effort to train the customer service people to be overly compliant, so that if somebody says they don't want to call, the customer service people will just tag it wrong number. Well, it wasn't a wrong number. It was a don't call me number. So that, and the plaintiffs will say, okay, let's start the class with everything tagged as a wrong number. Okay. And so now you've got all these calls that were never wrong numbers that are in that pool because they weren't tagged properly to begin with. I've heard one lawyer who's very well known in this area saying, don't even put a wrong number tag on it, because that's how they start identifying the class. Do something else, something vaguer, right?
No.
So making sure that your records are clear. And, I think one of the biggest risks right now is internal do not call, national do not call cases. And I it's the toughest thing I see my clients wrestle with, where somebody on one call says, don't call me, and it never gets into that CRM system, and so calls continue to be made. And that is the quickest way to have to write a big fat check, when your own records say, don't call me. And by the way, the plaintiffs will record these calls. The serial plaintiffs record the calls. So it doesn't help you to say, well, we just won't do anything, right? Which nobody would do. That's not the right thing to do. But they're recording those calls. And so it's very important to have a robust do not call system in place, so that you're scrubbing for national do not call, you're scrubbing for all those things. And, honestly, I haven't seen it, but I would throw it out to this group for the disclosures. Maybe there's a checkbox that says, I'm on the do not call, but, please call me anyway. I don't know. I mean, I know there's always a tension between the marketing push plus, the legal. The salespeople want a larger circle, and the legal people want the smallest possible thing. So there's somewhere in between. The reasonable road is found. But that, to me, is where I'm seeing a lot of risk as well.
That's interesting. That's really good insights through all that, Peggy, with your vantage point from seeing those cases, those sort of high volume. And can't agree more with all of those, particularly diligence. Make it a responsibility, not just in the beginning, but build a relationship. Your vendors truly are your partners and can be part of your success or your failure of stubbing your toe in the dark about their mistakes. So collaborate with them, have discussions about how all of us are looking at the changes, experimenting, what are they doing, and continue that relationship and discussions.
6 months in, a year in, pull 100 leads and pull up the consents and see what they look like.
Yeah. I certainly collaborate with them. Let's circle back to our poll question, get some responses and get some insight on that. So where are you in the journey of updating your technology and internal procedures for the FCC's one-to-one consent rules? You can see these responses in the poll section. So we have only 13% that said they haven't started yet. So that's great. People are minding our advice, which is the main thing we've been telling people. Get ready. Now is the time. You have an opportunity to plan and adjust and pivot and experiment. 60% want to learn more about technology that can assist with TCPA compliance. That's great. That's also what we're talking about here as well. And 10% say we have completed our testing and ready for the change. That's fantastic.
Wow. Great.
That's really interesting insights. Michael, you're our key data guy. What do you think of this spread from the poll?
Yeah, I mean, this is definitely improvements from some of our earlier webinars, Ben. We had, in the earlier ones, it was heavily skewed towards the first two answers. And, we had very few that had actually completed the changes. So it is these are welcome answers. And we're glad that there is improvement here. Peggy, I wanted to circle back on a couple of things that you had mentioned, just to make sure that the audience truly understood this. You had mentioned that, not just from a contractual perspective with your vendor, that, your contract obviously has certain requirements that the vendor adhere to, from disclosure language, scripts, right, et cetera. But performing these regular audits, as well as the retaining of records of consent, should be something that you actually have as the provider of the data to this third-party vendor. So I'll give you some examples of this. I always worked, when I worked with my different vendors, it was definitely a partnership type opportunity. But when it came to the documentation of consent, I always made sure that documentation of consent, which in our case is a trusted form certificate,
yes,
was available within my CRM system, as well as within downstream reporting systems that I had easy access to on my side. Now, granted, there are some cases where maybe it doesn't get transferred properly, et cetera, but you want to make sure that if somebody is generating a trusted form certificate, they deliver it over to you, and then you claim that certificate for your records. When it comes to the regular auditing of these call centers, you should be doing this. Some organizations do it on a monthly basis. Some of them do it on a quarterly basis. You want to do a large sample of calls, and you really want to think about some certain components to it that are important from a compliance perspective. And one of the biggest things you could possibly do is make sure that they're adhering to the scripts that you have.
Yeah.
When you're working with these vendors in the beginning, especially third-party call centers that are calling on your behalf, you want to make sure they understand, like, hey, here is the script that we have. This is what I want you to say on every single call. If somebody says, hey, don't call me anymore, I want to make sure that your agents are properly tagging that in your system, and that tag is being communicated back to my systems. So we don't run into a situation where this third-party call center gets a DNC request, and then 6 months later, I'm texting this customer who said, hey, don't call me anymore, right? And so script adherence is a very, very important tool in your compliance strategy. In addition to that, when you're thinking about scripting, I know, on the customer service side, scripting is very important, but it also can be important in sales too. It can help you to generate additional marketing opportunities. You can display the appropriate details to your agents so they can properly sell the product that you have. So don't just think of scripting as something that's solely used for compliance purposes. It can also be used to help drive sales and drive appropriate marketing details. Ben, what are your thoughts on that? Ben Zitter.
Yeah, it's so many good points there. One thing I wanted to add to that is the importance of ensuring that the brand that you use in scripting is a registered DBA. So we've seen issues in the past with other companies not having proper registration there. So I just wanted to point that out as a checkpoint to look out for. But for us, we've been trying to do a monthly audit cadence, and even then it almost seems like it's not enough. So I certainly recommend more frequent auditing than less, to say the least, to the extent your resources allow for it.
That's great. And Peggy, we have a quick question for you. We're first going to go to our next poll here, which is, are you currently reviewing your disclosures with your vendors? So if you guys could take the time in our audience and review that poll and answer them, we will review the results of that here in a second. We just want to go ahead and move on to the next topic here. So Peggy, this one's for you. We've received many, many questions over our different webinars from customers who are either the generators of live transfers or the buyers of live transfers. And with this new FCC one-to-one change, there's obviously certain components that are going to need to change in that process. What are your thoughts on that?
Well, it's interesting. I'm currently working on a matter where the lead generator worked on behalf of competitors. Their clients were multiple competitors in the insurance space. And so they would get a call, and then they would be asking questions of the consumer to try and determine which of their multiple clients they would transfer it to. Client A, B, or C, based on, could be a number of different points, demographics, et cetera. So our client was company A, which maybe got a third of the calls. The plaintiff's lawyer is arguing that company A is responsible for TCPA violations for every single call that was transferred, not just to it, but to all of its competitors as well. So that lead gen who was doing the work was making those initial calls as the agent of that company. And even if they didn't send that call to them, they're responsible, even if their competitor got the sale. Right, which is crazy. But that tells you the broad breadth that the plaintiff's bar takes on these cases. Okay. Now, on the one-to-one rule, you wouldn't, I think, be allowed to make multiple, make a call out and then choose amongst three. That kind of comes from that old school of, hey, you've clicked that you're interested in hearing about real estate, or you want to hear more about Medicare, or what have you, right? Mm-hmm. And so now I've got multiple clients in that base. So I'll, are you in, you're in California, I'll send you to client B. But it's very, very important to get that consent. And I certainly, and if you're the company to whom it's being transferred, you want to make sure, and you have an opportunity, I think, here in these calls to get the consent to transfer you to, to have that call transferred to you. So literally saying, I would like to transfer you to company A so that they can talk to you more about their products and services. Would you like me to do that? Yes. Boom. Now you've got, even if the original call was unconsented to them, you've got consent for that transferred call. So at least you cut the liability in half at that point. So those warm transfer calls, you're going to, like I said before, going to be responsible for everything down the line, from an agency standpoint. Even potentially, I can't believe that this lawyer will be successful with this, but I've seen crazier things with some judges, maybe even the ones that are sent to your competitors. So it's that whole relationship on the warm transfers. And I think what's also going to be very important is the capturing of the do not call, the revoked consent, the internal do not call, because if that company that's doing the transfers has gotten a do not call me, and then they call again and you get that lead the next time, or depending upon do not call me, and now they call 10 more times and it never gets picked up, those 10 calls are still, somebody may be liable for the calls where nobody ever picks up because the phone rang, right? So you want to be vetting that do not call, the documentation of do not call, the making sure that it gets implemented, that those become, banned numbers permanently. I've seen clients that have had a rule that I don't know where it came from. Oh, we just put the numbers back in after 6 months. Why?
Yeah.
Point out the statute where it says that's okay.
It's surprising. I've actually seen that in the past. It's obviously very rare and not compliant with the TCPA, but right. Every once in a while you encounter a customer who is unknowingly violating the TCPA. But I think it's important that we can dissect this for our audience too, Peggy, because I think you did a really good job with this. If I'm a live transfer generator, you have the initial generation of that lead. So that customer is submitting their information to you as the lead generator. They are providing one-to-one consent for you to contact them.
Yes.
Then you are outbound calling that potential customer, and you may ask them a couple of pre-screening questions. But then the second component is you need to gather consent to transfer them now to the lead buyer or the live transfer buyer. And what does that process look like? Is that something that is on the phone? Is it a verbal consent, or is it a situation where, if you want some really, really good documentation, you might send them like a text message, send them to a form, have them opt into to the live transfer buyer to transfer to them, and then transfer that call. And there's many, many different components, and there'll probably be very, very many models that come about when the FCC's one-to-one consent change comes into play.
Yeah. And the theme of all that is looking for the opportunity to document consent, capture it, make sure that you have it available, and that matches with even some of the specific items that aren't quite clear from the rule updates. That part is clear, that the FCC wants to make it more singular, that the individual knows where the data is being transferred, where they're going, and that all fits the spirit of those components too. So sometimes when it's not clear, look for extending that as far as you can in your process, and that you're documenting and making sure that it's more one-to-one for sure. Let's circle back to our poll question that we had. Are you currently reviewing your disclosures from your vendors? 48% yes, 39% no, and 13% want to learn more about our solution, Trusted Form Verify. Michael, what do you think of those?
Yeah, so this is actually, I've seen these types of poll results before. It tends to actually be about a 50-50 mix here, where I see some companies just trust their lead providers to have the appropriate disclosures on their landing page and just assume that they are being compliant. And then there's the other 50% that perform regular audits that are required by their compliance departments. This tend to be more large enterprise level firms that do this. So my opinion on this is that even if you're buying leads from reputable sources, you should always be monitoring your disclosures. In the case of a TCPA lawsuit, there's many, many different components that the plaintiffs are going to go through and review and request for that data. If your disclosures don't provide the consent for your firm to contact them, you're pretty much SOL. When it comes to a TCPA complaint. It's probably one of the most important components besides the documentation of that consent, that the disclosure language is correct and accurate and meets your compliance needs. So with the Trusted Form Verified product that ActiveProspect has, we have the ability for when you purchase leads, you claim your certificate, we can actually take that disclosure language and have you review and approve it. Now, if a lead comes in that has unapproved disclosure language for you, you can actually reject that record and make sure that you are not accepting leads that do not meet your disclosure requirements. Now, that being said, with disclosures, especially if you're new to this particular topic, you want to reach out to your vendors first. Have them provide you with the disclosures that display on their page. Have a good conversation with them. Often these vendors can be flexible with this, especially if there's certain things, upcoming regulations that are coming. They can and will make these changes for you. Some of them they won't. I'm not going to say 100% of the time they're going to do it, but for compliance purposes, they tend to be flexible to your needs. But I always recommend that you monitor your disclosures. I did it on a regular basis. We offer the ability through our Verify product for you to do this programmatically.
Yeah, and number two, get legal review of those disclosures. Get some outside opinion of that, internal, outside, whether your language is drafted in a compliant manner. There's lots of details associated with that. There's opportunity to include disclosures from other data regulations that are in point. So it's important to get legal advice and input from someone in that space who is very informed and knowledgeable.
I was just going to say one other thing that's important in this area is making sure that the ability for your third-party vendor to outsource their responsibilities is limited, if not cut off completely. That if they're going to outsource anything, that you maintain control of it, because you may have looked at their policy, their disclosures, but if they're now buying leads from somebody else who's buying leads from somebody else, you haven't seen the actual disclosure that the lead agreed to. You've only seen one up the chain, which is completely irrelevant to that calls to that particular number. So you're going to need to make sure that you've got your hands around any of the outsourcing, if you allow it at all.
That's right. And I think it's also important, Peggy, to point out that, there are some instances, and, I've seen companies that have been sued through TCPA from this, where you have a lead that may have been resold multiple times, and then eventually it gets sold to you. Right now, in this new one-to-one environment, you need to make sure that end lead that's being sold to you has that one-to-one consent for your organization when this change comes into play.
Excellent. All right, let's shift to, we've got a pretty active audience here. They've been submitting some questions to us, so let's dive into some of these. The first one, I'll summarize this one. It's so with the one-to-one rules, won't that supersede the DNC? Because they have to give their authorization to be called to a company. So technically calling them would not violate the national or state do not call lists. Is that correct? My understanding of this is, yes, that's the idea. So someone can be on the national do not call list, but if you've captured consent appropriately, then yes, you can contact them. Yes. Any other comments from anyone else? That's pretty straightforward.
Yeah, I think this kind of goes back to our disclosure discussion. So oftentimes the disclosure should explicitly say that you're providing consent to be contacted, even if you are on a state or federal do not call list. I've even seen some disclosures expanded to include a internal corporate do not call list as well.
Yeah. And
there's a statute of limitations in that though, because there's only, what is it? I'm going to get it wrong. 3 months
90,
pardon me?
90 days.
90 days. Right. So it isn't this blanket. Sure. You know, it's okay. That what dates did you get that consent to call? Let's say Hilton Hotels. I give, consent to hear about Hilton Hotels, Grand Vacations, whatever. That's only going to be a 30-day thing, because they're not, unless they're customers, unless there's been a transaction, unless there's inbound calls. There's a lot of important things that go into that. It's not a blanket. So those deadlines those dates are really important.
Mm-hmm. So Ben Zitter, I think this is a good one for you. One of the questions on here is, if in our business we are purchasing leads, should we expect the lead vendors to provide us documentation for the consent? And if so, what should we specifically ask for?
Yeah, if the buyer is buying leads in order to call upon that lead, absolutely the lead generator has to provide proof of consent, which should include the certificate showing, the basic details of engagement, IP address, the URL of the site that the person provided consent on, and also a playback that shows the user consenting on the applicable TCPA opt-in form. So it's very important to also have that playback, not just the certificate. We've seen issues come up where third parties don't provide a full certificate when we ask for proof of consent. So it's important.
All right, let's see if there's any other ones that are in here.
I've got one. How do the new regs impact companies that are dealing with not leads, just demographic data that has been litigated or DNC scrubbed? So again, not legal advice in any way here, but if it's just demographic data and you don't have consent to contact them by text message or phone, you're certainly taking a chance with compliance for TCPA. Not part of that is whether those leads that you've acquired have the consent part of that, but if the nature of that question was, if you just have information and you're just trusting on litigator and DNC scrub, you're taking a chance. But if a third party's captured that on your behalf and you're able to look at that consent and you both have a record of that, then that would be the safer side to be certainly more compliant. Any other comments from anyone else? All right.
Yeah. All right, let's see here. Just a quick comment here. We did have one of the comments in the chat where somebody asked if we are going to be sending a copy of the recording. Yes, we will provide a copy of the recording of this webinar to you at the end of this session. All right, let's see here.
There's one for consents that we obtained prior to January 1, but are dialed after the effective date of the regulation. Will you need to have one-to-one consent for that one?
Yeah, so I'll start with this one. Peggy, I'd be interested to hear your thoughts on this as well. This is something that we expect to be litigated in the courts. The FCC rule for one-to-one consent, it takes place in January, but it doesn't actually explicitly say that it affects only leads that are generated from that point forward. So there is a real possibility that when this rule goes into place, that this could also be applied retroactively. So if you purchased a lead prior to that date and you did not have one-to-one consent, these litigators could try in court to get you for a TCPA lawsuit because you had purchased that lead. It did not have one-to-one consent. That rule change came into place. If you called them after that date, you could potentially be in violation of the TCPA. Peggy, what are your thoughts on that?
Oh, I agree. I mean, you got to remember the FCC, those are guidelines, right? And it's the courts that can make a determination as to whether or not something is retroactive. It may be that a court could find, for example, that these guidelines were provided, on such and such a date, and you were given X amount of time to become compliant. So anything after the issuance of the guidelines, anything being gathered now should be compliant. That could absolutely happen. Certainly the plaintiff's lawyers will make that argument. Anything that's going to make their pool of violations larger, they will argue. I mean, they certainly will. There is also, a school of thought and probably some judicial opinions will come out that will say, nope, that has to be as of January 1. That's, those have to be compliant. But if you're calling on leads that were generated, if you're calling after the application of the rule, but on leads that were generated beforehand, I think you're very much in trouble. You're very much at risk at the very least. That if you're really trying to stay out of the litigation limelight, I would get compliant on that as soon as possible, and certainly not be calling after the application of the rule on leads that don't comply, because that's just an easy argument. Remember, when you can write an argument out in crayon, you usually win, right? But then the defense has to be this complicated thing where there's a lot of explanation. That is not the situation you want to be in as a defendant. You want to have an easy defense that says, this is when the rules came out, we got compliant, and those are the calls that we made.
And Peggy, I think we had talked about this on a previous webinar, and I think you really made a good point there, which is where the rule takes effect in January. But if you, as an organization, and your compliance department's legal opinion is that, hey, we can contact leads from the time we get consent up to 90 days past that, then what you need to be doing is starting to discuss with your lead vendors as well as your internal marketing teams about making these changes for the one-to-one consent a little bit early, because that way you don't have a situation come January when this rule change comes into effect that all of a sudden you have a subset of your leads that you generated in the past that you can't contact anymore for fear of TCPA lawsuits.
Okay, now let's, we covered lots of good topics here today. I think now let's go into some key takeaways. Michael, what's your thoughts on the key takeaways from what you heard here today?
Oh boy, yeah, so much. First of all, it was a great discussion. We obviously went through quite a bit here. I would say our key takeaways here is, number one, you should really be using reputable vendors to ensure that you are staying compliant with existing laws. If you're going through all the vendors that you work with, you should be regularly discussing your compliance practices and make sure that you are in an understanding of what your MSA should be and what sort of practices they should be doing within their third-party call centers or whatever tools that they're using. Number two, you should perform regular audits of these vendors' activities. So, Peggy, you made a good point about this. If you have a partnership with a vendor and they are doing outreach on your behalf, you can't just say, oh, it's in the MSA, I think we're good on this part. You need to actually be doing tests with them. You need to say, hey, provide me some recordings, do random testing on them, make sure that if they are capturing consent, that you also have consent on your side. Make sure your systems talk to each other. So if they get a DNC request, it goes into your system. You're not inadvertently contacting somebody. The other thing I think is it's going to take time for your organization to prepare for the FCC's one-to-one consent changes. So if you have not started the process of planning this out, you're really going to want to start right now. We talked a little bit about retroactive consent towards the end of this webinar. you're going to need to start approaching some of these lead providers and saying to them like, hey, I need you to start this a little bit early because I don't want a situation come January that I can't call these leads anymore. We want to make sure that we get good value out of the leads that you're providing to me. And so you're going to want to start planning this out both with your vendors, but also with your internal departments.
Yeah. Thoughts from anyone else on key takeaways that we haven't covered?
Well, I'll wrap it up in an answer to a question that I'm seeing here, which says, if your lead provider assumes all right as per your agreement with them and absolves you of everything, you're okay, right? No. The key takeaway, and by the way, the fact that there are this many people on this call who are that interested in compliance, I think all of you who are on this phone are doing exactly the right thing. And the reason why the answer is no is you are responsible for everything, regardless of whether or not your vendor says, hey, no problemo, I got you. I'm responsible for everything. No, the law says you're responsible for what they do. Now, from a legal perspective, if they've provided you a bond or they've done other things, that's all good, and it's great to get that indemnification. But what if by the time you all get sued because they've made literally millions of calls that they shouldn't have made? They're gonna just disappear. They're gonna go bankrupt. They're going to create a new company. They're going to go to Guam, whatever it is. And if you're a real company, you're going to be left holding the bag regardless of what your contract says. So for me, the key takeaway is you are responsible for what you do and what your third-party vendors do. And you're responsible for being compliant, and you need to ensure it yourself. And promises in a contract that a third-party vendor is going to be compliant is great, but it's not enough. You have to verify it.
Excellent. Yeah, I mean, it's been very clear in our related conferences when the FTC or FCC appears. They've been talking about, well, there's the rules in finance of know your customer, and the model there is also know your vendor. So that's just not looking at their promises. That's looking into their background and their company structure and who they are and what are the previous where have they appeared before and disappeared? Those kind of mechanics are really getting to know your vendor of a basic background check in that space. So I'd also highlight that one as well. All right. We're going to fire up our last poll. This is our last chance, everyone out there, for let us know if you're interested in learning more about ActiveProspect solutions. So please register that responses in your poll there. And I want to make everyone aware here that our next session webinar is on June 12th. It's going to title is "Don't Play the Waiting Game: Strategies for Anticipating TCPA Updates." We have some great speakers there, featured from Kelly Dry and Warren Law Firm, Alyssa Hudnick, and also Jeannie Wainwright. So we look forward to further details in that discussion as well. And I certainly want to thank our co-hosts and presenters today. Peggy Daley, thank you for your insights. Benjamin Zitter, thank you for sharing the journeys of What If Media. And we look forward to continue to working with you all as we all navigate the FCC TCPA changes in a compliant manner. Thank you all very much.
Thanks so much for having me.
Thank you.
Great.